I know the court's in a difficult position, but at this point, we're at that impasse of if she walks out of every conference that I have with her, I'm not sure what that says about the attorney-client relationship.
Ma'am, you said there was something else that you had other than a 58-page submittal or letter. What other information is it that you're seeking to have me take a look at?
It's things that I've been working on in the meantime. It's things that she likes to tell me is not necessary, but I know for a fact it is necessary. She likes to, in quotes, put things to rest all the time and constantly tells me I'm not having this conversation with you. So I'm not going to waste my time, and I, being in jail, have supposedly abundant amounts of. She's not going to waste my time because she's not going to explain something to me. And I have taken it upon myself to explain it to myself because she refuses to do so. I don't understand what it is that she has against me. I have told her from day one that her snotty attitude was inappropriate, and I try very hard to bear with her and her attitude. I don't know what it is that I'm doing wrong to her, but I feel that her attitude has equaled prejudice, which is not in my favor, especially considering she supposedly represented my life.
Okay.
Welcome back to another episode of Dreading, or if this is your first time here, welcome. Today, we are once again revisiting the case of Sarah Boone. While the case itself is incredibly cut and dry, with Sarah filming herself laughing at her victim as he lay dying, it still has not gone to trial 4 years after the crime was committed. Sarah still doesn't think she's done anything wrong. She believes that while yes, she did technically kill her boyfriend, and yes, she did film herself enjoying the fact that he was perishing, that she isn't technically responsible because, in her own words, she didn't mean to do it. In her mind, if you didn't mean to commit the crime, but still committed said crime, you should be let off with a warning and a slap on the wrists, especially if you were someone like her who did really well in school. That is almost a verbatim quote from her, which is really astounding. I'll leave a link to a playlist with all of our coverage of Sarah thus far in the description box down below. But be warned, that is over 5 hours of content, not including this video. If you have watched all of our previous coverage of Sarah, then you would know that the reason for this case not moving to trial falls squarely on her shoulders. Sarah refuses to comply or work with her lawyers, as they are public defenders who have other cases. Initially, she had a private attorney, who her ex-husband was paying to help her, but given her position in prison, he has opted to stop supporting her outright. After this private attorney, she began to use public defenders who Sarah admonished for not giving her case the time and attention it needed. We know this because Sarah began to write letters to the court, telling the judge in her case that her lawyers were working against her, which were lazy and stupid, and that she was being railroaded. She would also remark that it would be impossible for her case to go to trial because of coverage like our own. She would say because millions of people have watched the video of her laughing as her boyfriend lay dying, she would not get a fair trial, and she should be released from custody post-haste. Those initial letters regarded the judge in her case as being fair and noble. However, when he refused to give her what she wanted, her ire turned his way. In later letters, she would state that he was corrupt, that he was personally profiting from the continued coverage of her case, and that she was going to be writing to the governor of Florida regarding the matter. Again, she framed this as being a sort of trump card in her letter, as if she was telling a barista that she was going to call corporate over a bad coffee and get them fired. It would surprise only Sarah that that didn't work. At the time of recording, she has gone through 8 different lawyers and accused them all of ignoring her and not giving her case the time and attention it needs. She has accused the original judge in her case of being corrupt, and has even gone so far as to state that her ex-husband was somehow behind why she is still in prison. Our comprehensive coverage of this case and the previous letters will be linked below, should you want to hear her statements for yourself. We last covered Sarah 8 months ago, when her 7th attorney asked to be removed from the case, citing irreconcilable differences. Notably, this has been the 2nd time that the lawyer has asked to be removed, given the first time they were told by the judge that they needed to try and work things out with Sarah. Since that time, the judge on the case has changed from Judge Wayne C. Wooten to Michael S. Kranick. Directly after the new judge was assigned to the case, Sarah wrote the following letter. January 19th, 2024. Honorable Judge Kranick. Finally, a new judge. It's strange how the Lord works, as I was in the process of trying to disqualify Wooten after being my judge for 4 years. and me still incarcerated with nothing new to show other than 7 different attorneys, not by choice. News clips of me walking in and out of the courtroom and everything relative to my case permitted to be slathered on the global internet, and in which I have not seen myself. So, pausing just for a second, we're already starting off strong. Immediately, a few things jumped out at me about this letter. First being that she is back to calling the judge in her case honorable. If you recall the first time we read out her letters, they were full of ass-kissing praise and reverence toward the initial judge. She spoke to him as if she were a kid, wrongfully sent to the principal's office over a prank. She stated he was a noble and kind person, and would obviously see that a miscarriage of justice was taking place and release her. When that didn't pan out the way she believed it would, he became the subject of her ire. If he refused to see her as a penitent victim, he would come to know her as a thorn in his side. She illustrates this for us by stating she was trying to get him disqualified before she ever actually went to trial. But to be clear, at least in this case, he hadn't done anything worthy of being disqualified. As we mentioned previously, Sarah is upset that details of her case, including these letters, are easily accessible to the public, and that there are people like myself who review their contents online. She believes that to be a violation of her rights, and that somehow the courts are conspiring against her. However, that's just what happens if you kill a person in Florida. Florida has some of the most robust sunshine laws in the United States, and that's the reason why you see so many examples of Florida man or woman, crazy true crime story. Sarah has been told that countless times by her lawyers, by the judge in the case, by channels like my own, and by people who watch videos like this one, who then feel compelled to write to her in prison. People have made her aware that she is not being unfairly targeted and penalized, but she refuses to acknowledge that fact. But it does not align with her need to be the victim in this case. She has shown herself to be incredibly narcissistic, so anything bad that happens to her has got to be the worst thing that has ever happened to anyone. As far as we are able to tell, she believes that the entire criminal justice system, including the previous judge and all of her lawyers, all conspired against her after she murdered Jorge, as well as illegally distributed the video of her mocking her dying boyfriend and having made millions off of her name. And how exactly have they done this? She doesn't know, but she is the hapless victim who needs to be saved in this scenario. Sarah has also reverted back to the statement, not by choice, which she has used in nearly all of her correspondence with the court in this case. We've seen this in other letters, where she recounts how her awful, ill-equipped, stupid lawyers keep filing motions to withdraw on her. In her perception of events, she has done nothing wrong to her lawyers that would make them want to leave her defense, and yet they keep dropping like flies. But therein lies the issue. Sarah wants to be allowed to publicly admonish her legal team, to say they have no idea what they are doing and are bad at their job, while still working with them. She only states that they are bad at their jobs because they are not doing what she wants when she wants them to do it, and believes that they will be more motivated to help her by doing so. What she doesn't realize is that that tactic hardly ever works when dealing with someone working alongside you, but it would never work with your legal team on a criminal case. If a defendant publicly states that they feel as if they are getting bad legal representation, that is cause for the defense to withdraw entirely. Every time she speaks ill of her lawyers, they have all almost immediately turned around to file a motion to withdraw, and have told Sarah that that is the reason behind their decision, yet she cannot accept that. In Sarah's mind, if she believes you have wronged her in any way, shape, or form, she is allowed to respond however she sees fit. She can tell people that you're stupid, you're bad at your job, leave you locked in a suitcase all night until you die, anything. The sky's the limit. But if you respond, you are the antagonist. No matter what, you are in the wrong, and she is in the right. I suppose you can kind of do whatever you want, but you do so at your own peril. You're really only allowed to do what she wants you to do. Anything else is an affront. But let's continue and see if anything I have said is substantiated. I felt he was the ticket holder to my overly hyper, illicitly distributed, misconstrued criminal case, and great reason I am still here. Again, ongoing 4 years and 7 attorneys later, not by choice. See letter dated 6/29/23 on clerk's website, while still waiting to properly elucidate the court. Alright, I'm pausing again. So we're back to this. Sarah is busting out her thesaurus for these letters, like she did in the first 3 she sent to Judge Wooten. This is how Sarah attempts to align herself with people she views as important. She did this when she was arrested and described herself as an intelligent woman who got really good grades in high school, despite the fact that she was multiple decades out from said grades and was a non-functioning alcoholic. Sarah isn't stupid. She knows that the judge in her case is an important person and someone she needs to get on her side. He needs to see her as a good woman in a bad situation and wants to help. So, naturally, when addressing him, she's going to bust out her big words and try and indicate that she is too smart to be in prison. Continuing on, while still waiting to properly elucidate the court, public, and world, and after whatever the dysfunction was in the attendance part of my most recent pretrial conference/status hearing, which I am trying to ensure my automatic attendance futuristically, please see my draft motion that I included. I am still trying to have my attorney submit on my behalf. I wanted to bring to your judicial attention the following information so you and the world are aware it is not who I am ever delaying trial, as Wooten inappropriately accused me of doing in a past hearing, especially now that you've mandated a trial date to be had in May, with no further continuances, leaving less than 4 months to put together and complete what should have been done already. What happened in the 4 years prior? Please read all of my correspondence online. Pausing before we read Sarah's list, I think it's important to note that what Sarah is saying here is likely what she actually believes. As ludicrous as it sounds, Sarah's mind does not work the way yours and mine would. She does not see her own faults, and does not acknowledge them at all, which leaves her constantly scrambling for other people to blame. In her mind, she genuinely does not see the correlation between her actions and the response that she's gotten. She does not see anything wrong with talking poorly to her lawyers, writing essays to the court about how she is being undermined by her own team. And so, when they leave, saying that that is the reason they need to go, she simply doesn't believe them. Though we can see and understand that she is the problem in the situation, she cannot. But, continuing on to the list. To date, Winston E. Hobson has been my court-appointed attorney for 133 days and counting. To date, Mr. Hobson has only met with me one time for a total of 3 hours. To date, no phone calls have been received by Mr. Hobson, as his phone does not work properly for further immediate, much-needed communication to be made between client and attorney. To date, I have mailed 5 letters to Mr. Hobson, trying to communicate my urgent need to speak with him. To date, I sent 1 letter to the investigator in my case to contact Hobson to contact me to see if he can assist in correcting the phone problem, also to inquire when anyone is coming. To date, I feel I am not being included or heard or cared about in my case again from the continued miscommunication again with Mr. Hobson, and time-consuming, undiscussed entries being made on my behalf. The continuance I did not know about, the waivers of appearance I did not know about, along with other documents. And I am never sent copies of anything filed, so I know. I keep trying to tell him about, with no response furthering the already massive dysfunction in my 4-year case. So pausing here for just a moment again, Hobson is a public defender. The man is busy with cases just as pressing as Sarah's. He doesn't have time to guide Sarah on every filing that is being made and everything that he's doing in her case. Because, to be quite blunt, Sarah is still an idiot. By her own admission, she states that she cannot understand that locking someone in a fucking suitcase would result in their death, even when the person directly told her they were dying while they were dying. If he were to try to explain every decision being made in the case, why he needed a continuance, why he filed a certain motion, and everything he is doing, that would take an ungodly amount of time, especially since Sarah believes that if she continues to state that she didn't mean to kill Jorge, she will simply be released. If she wants a more hands-on approach, where someone is being paid to hold her hand and explain legalese to her, she would need to get a private attorney. In my opinion, one of the main issues that keeps popping up in this case is the fact that Sarah believes she is a legal expert, or at least as intelligent as her lawyers. She thinks she can mentally keep up with them, and that everything she has to think and say about the case is vitally important. But to be frank, she has nothing of value to add. She weighs down the case with her idiocy, and even when her lawyers have tried to appease her, it doesn't help at all. Sarah continues on. I was hoping in the pre-trial conference/status hearing on Tuesday, January 16th, 2024, I could at least play catch up in the courtroom for 5 minutes, so many of my attorneys have done prior, including Mr. Hobson, and the one court date I've had for a continuance to express and emphasize the need for him to communicate and schedule a second very overdue meeting. I still have not even heard from Mr. Hobson about our missed pre-trial conference/status hearing. What's the status? To date, 1 out of 133 days and counting, attorney and his client have met. To date, 2 out of 3,192 hours, attorney and client have discussed partial general case information. To date, I still have not seen my discovery. Your Honor, when is the next status hearing, please? Especially since I/we were not at the last pretrial hearing/status hearing. And especially since I am trying to communicate with my attorney in more than one way to fully maximize and utilize the minute amount of time allotted before trial, my fair, appropriate, lawful trial. Pausing again, once more Sarah believes she is an asset to her legal counsel. She believes, despite everything and everyone in the world telling her otherwise, that she is the only one capable of creating a solid defense in her case. Sure, she recorded herself killing someone, but she can just easily explain it away. The only issue is that seemingly every lawyer in the state of Florida is incompetent and out to get her, which makes a lot of sense if you really think about it. I'll give everybody a moment to think about it. Alright, and moving swiftly along, whenever Sarah details all the ways she has tried to get into contact with her lawyers, it reads as harassment. Her lawyers have communicated with her, she just doesn't like how it's done, so it simply doesn't count again. She doesn't like that they are in charge of her case, so she admonishes them publicly, with the idea that they will bend to her will. So she's basically a nightmare. And every time she loses another lawyer, that's months of catching up her new lawyers have to play, trying to determine how they would argue the case and how they will handle Sarah's personality. It would be irresponsible and unethical for her to be assigned a new lawyer and immediately charged into court. But alas, she doesn't see it that way. She is the victim in this circumstance, so every time she writes a letter like this one, she is the scrappy underdog, fighting for justice. Meanwhile, it's her stupid fucking ex-husband's fault that she is in prison, or her lawyers, or that goddamn Judge Wooten. The onus of responsibility is never hers. But she continues on. I am still wondering why, though I've had to wait 4 years for something to finally happen on/in my case. Ask Judge Wooten. I wonder also, was I the oldest case on his docket? Either way, I'm still here, waiting patiently and very excited to get this highly anticipated, quote, show on the road. I await your overdue and very needed judicial direction, supervision, and intervention. Thank you in advance, Judge Kranick. Welcome. Sincerely, Sarah Boone. And that concludes that letter. And following said letter, Winston Hobson filed a motion to withdraw from the case. In his motion, he cited ethical considerations as being the driving factor behind not wanting to work on the case any further. Sarah was then assigned her 8th lawyer, Patricia Cashman, on February 9th, 2024, and for the next couple of months, things were radio silent on the Sarah Boone front. Usually, Sarah would write one long, scathing letter a month, detailing all the injustices she has had to face since killing her boyfriend, and how the entire system is set out against her, but she stopped. Everything was silent until June. According to the county clerk website, on June 7th, 2024, a status hearing was held regarding the case, just to see if all relevant parties were able to take the case to trial. Since the withdrawal of her initial lawyer, all these conferences have been her lawyers asking for more time, stating that they aren't ready to go to trial, and detailing their issues with Sarah. But this time was different. Sarah had not written any letters to the court between February and June, but not because she was satisfied with her legal representation. According to the court minutes, during the status conference, Sarah stood up and spoke about her concerns with her new lawyer, Patricia Cashman. Cashman attempted to address Sarah's concerns, and Sarah responded by providing a 58-page letter to the court. Great. We are about to read this letter, but it should be noted that the same day of the status hearing, when this letter was given to the court, Sarah's lawyer filed a motion to withdraw. Once more, this motion to withdraw cited ethical considerations that prevented her from working with Sarah. So whatever is in this letter, whatever Sarah said in court was the final straw for Cashman. So let's tackle this monstrosity. I dig it. Sarah begins. Honorable Judge Kranick. Okay, pause. This is already interesting. Despite the passage of time that has lapsed since she last spoke to this particular judge, I was wondering if she would continue to hold him in such high regard, or if she would decide that he, like Judge Wooten before him, was a part of a larger conspiracy against her. It took a couple of letters for her ire to focus onto him, and seeing as she has been relatively well behaved, it seems he is still in good standing. For now. All this means is that this letter will likely place him on a pedestal. She will regard him as being her final hope, and attempt to endear herself to him. I also want to preface this by saying that she starts this letter writing in a form of cursive, so it's a bit harder for me to read. So please be a bit patient with me as I might get some of the words wrong. Okay, I'm probably going to get some of the words wrong. But Sarah continues on. Ongoing 5 years. Why can't I use my constitutional rights? Am I the only one who cares about the ongoing violations of, or have a bond? Okay, pausing again really quick. Her constitutional rights are fine. I haven't stumbled across any actual violations of her rights. And despite the fact that she is a murderer, I would have pointed those out. And the bond is an easy one. You can't bond out of prison, mostly because you murdered someone. You were considered a dangerous person who recorded yourself gleefully murdering someone, so that's why you were not allowed bond. Though it can change case by case in Florida, if someone is charged with second-degree murder, which she is, they are not eligible for bond. But again, she continues, have all my medical records, have all my digital evidence in discovery, have all my paperwork, notes, letters, pictures, everything of mine returned by former attorneys, speak to my investigator, have a complete download of my phone, have any of my witness lists, give any insight, understanding, clarification, truths about my case, especially to my attorney, be listened to by anyone, especially my attorney, be respected for who I am truly, especially by my attorney, and not be disrespected for the mutated, malicious murderer all the world has falsely, incorrectly created and believes me to be? No, okay, pausing again. Sarah murdered someone. Even if that was an accident, her actions directly led to a person's death. That is an undeniable fact, with undeniable evidence that she created herself. The story of what happened to her has not been mutated or falsely represented. She locked her boyfriend in a suitcase when they were drinking. She drunkenly filmed herself mocking him as he pleaded for his life, and she left him in the suitcase to die overnight. Those are the facts, plain as day. There is debate on whether she meant to kill him or not, but her actions led to his death. Moreover, her legal team has access to all the discovery in the case. They are the ones putting together a legal argument for her, and they are actually competent enough to put together a case that could benefit her. Giving her access to all her medical records, the discovery, and everything else she listed would be highly irregular and only make things harder on them. She's not an attorney. She is a drunk who believes she is a genius. Giving her access to everyone on the witness lists and all the evidence would only allow her to do more idiotic things like witness tampering. Though anyone would want to feel like they have an active role in their own defense if they found themselves on trial for murder, that is not advisable in this case. Her giving insight on her case, as she so eloquently puts it, is her either lying about what happened and saying she didn't mean to kill Jorge, which is as stupid as it is unhelpful. And after seeing Sarah burn through 7 other lawyers, Cashman likely believed that if they were to examine the case without Sarah's input, they could provide a better, more succinct argument. Sarah wants to be treated like a lawyer and continues to get upset when the court points out that she isn't one. She continues on, be treated fairly, lawfully, and be protected by the quote, justice system, properly, rightfully, completely defend myself. Bingo, there it is. Pausing again, we've been saying since our first video on Sarah that she desperately wants to represent herself, and she will not be satisfied if she is not allowed to say and do what she wants at trial. She's not a lawyer, and she doesn't have the knowledge required to provide a robust defense. But she believes that if her lawyers acted as an extension of herself, simply doing and saying everything she wants them to do, her case would be wrapped up in a second and she would be a free woman. At every point in the case, she has shown that she believes that she can talk herself out of any situation, despite it never working, and now she is saying it outright. She continues on. See all and know the same as the world can and does, including my attorney, from all the phenomenal, non-permissive amount of my case being available online globally. Before my trial, and most important, before I have seen myself, what doesn't anyone know already about my case? How about my side on everything about everything? Be correctly understood that I am not the problem for reasons I am on malappointed by the court attorney number 8. See my letter 72123. Say what I want and should, but all the world can, and say it all wrong and warped. Why won't my attorney give me an honest answer? Show me everything she says she has and finished reviewing for my case, but withholds from me after I ask repeatedly for and about? Give me an answer other than, I'm putting this to rest. That's not necessary. Or, I am not having this conversation with you. Pausing once more, Sarah is telling on herself a bit here, because she has gone from saying my attorney isn't answering my questions to saying my attorney only answers my questions in these 3 ways. However, it goes a bit deeper than that. The phrase, I am putting this to rest, tends to be only used when a subject matter has been exhausted. It means her lawyer has said all she can on the matter, and therefore she is done talking about it. But Sarah doesn't like the answers she was being given. We know at least one of the subjects that this is about, that being videos like this one, discussing her case and court interactions. She believes that by people reading her letters, reading the court documents, and commenting on the fact that she's guilty, her rights are being infringed. She has said on numerous occasions that she believes videos like this one should be investigated, because it's likely that we work with the prosecution, and potentially the entire criminal justice system, just to make a profit. In her last letter to Judge Wooten, she directly accused him of selling the video of Jorge's murder himself, and demanding to know how much money he made. Her lawyers have likely explained to her on numerous occasions why that video is publicly accessible, why it is not grounds to dismiss the case, and why it being viewed millions of times does not directly mean her future jury will be tainted. But she does not like their answers, so she ignores them and pretends the answers were never given in the first place. When she asks the court questions, she doesn't actually want an answer. Sarah wants to be told that she is right and she is a victim, and to be doted on as such. She continues again. Grant me access to anything I ask her for in and about my case? Like the detectives in my case, stop putting words in my mouth? Tell me what's going on in my case. It's been well over 100 days. She has been my attorney, and I still do not know. Ongoing 5 years. Answer any of my questions. Ever ask me any questions? How can she supposedly know everything she needs to know from what she's been told, heard, read, or seen? Reassure she's on my side, not against? Why have I already been judged in the court of public opinion? How did that happen? Why have I been sentenced by anticipation and condemned before my predicted trial? Why does my attorney and all of the world think that my case is already over? Pausing again. No one thinks her case is over. In fact, most of the people who are apprised of the case details are waiting for the case to go to court with bated breath because they are both disturbed and amused by Sarah's antics. Also, I think this goes without saying, but most people believe she is guilty because she recorded herself taunting her dying boyfriend before he perished. It doesn't get more cut and dry than that. She continues. Your Honor, during our first introduction, at my last withdrawal of court-appointed attorney number 7, Hobson, you stated to me your uninvolvement with any of my letters I write. I am still going to write my letters, as conduitely they are to the world where my potential jurors are located, and this is the only way anyone, including myself, knows the very necessary insight to my continued disadvantages, hindrances, impediments I am still experiencing on top of new, spurring my intentions to write. The race to the pulpit is unfair, and it is important to me that you are aware and understand what transpires when the news cameras are off, and we're all in between my, quote, status hearings. Alright, so pausing again. On the last page, Sarah spoke about how her voice is being squashed down by the system, and how she felt like she wasn't allowed to speak about her case while everyone else could. She thought it was unfair that her legal team had asked her to stop talking, because everyone else is allowed to say what they want. But here, she blatantly admits that she writes these letters with the understanding that they will be seen by other people, that the judge does not look at them, and that the only purpose of the letters is to speak to the world at large and tell them how she is being unfairly penalized. The issue is that she doesn't realize that her lawyers have told her not to talk about the case and not to speak publicly for her own protection. They aren't trying to silence her. They aren't trying to throw her under the bus. They're trying to give her the best chance of getting out of prison someday. But Sarah is too stupid to realize that. Every time she opens her mouth, every time she writes a letter and accuses a new party of framing her, that is the evidence that the prosecution can use against her. These are issues that are going to be brought up in court to make her look paranoid and vindictive. One of her first lawyers has spoken about the defense strategy they wanted to use in this case. They wanted to focus on the abuse Sarah was put through at the hands of Jorge, and center their arguments on the fact that Sarah was a normal person who had simply made a mistake after years of torment. Their goal was to make her look fresh-faced, mournful, and timid, to present her as if she couldn't hurt a fly. But every time she writes a letter like this one, that defense becomes a harder sell. She's coming across as argumentative and aggressive, like she cannot handle when things don't go her way. She has too much pride to go along with her lawyer's strategy, so she continues to run on this hamster wheel, forcing her lawyers to withdraw, then using that as evidence when she claims that everyone is against her. She continues. 2. As so many of the advantageous embezzlers, racketeers, mindless lemmings, and just altogether mean people can use their quote-unquote freedom of speech, not knowing me in any way, other than what's being said by all the other mean people, and being said incredibly incorrectly, so can I. Pausing once more, it should go without saying that it is not mean to say that Sarah is a murderer, because she objectively murdered someone. That is a fact. Moreover, I do not need to know Sarah personally to say that, or to pass a third-party judgment on them. Similarly, people are not mindless lemmings if they watched a video of you committing a crime, then believe you to be guilty. Continuing on. As the compelling, annoyed detectives in my case, Copesal had to falsify documents, and Lowen wore his gun for me to see. I am sure you are familiar with after watching all of my plastered, highly misconstrued, over 30 million plus views just on one site, quote, interviews, and in which they both attempted to quote, unquote, feed me their incorrect, incomplete, hypothesized opinion by stating to me, quote, everyone has their limits, at the seemingly endless point of perpetuity of nonsense and lawlessness, still growing, and I very much want to advance to the next level after ongoing 5 years now. A genuine concerned limit has been reached. Why am I still not being included in my case? How much more of my case and self is being added hourly, especially after this letter gets loose to the internet, increasing the mass infection and destruction of my hopes to have a fair trial? Anything fair, my side foremost, and wondering now if my attorney, quote, drank the punch, just like everyone else. All aforementioned reasons, and so many more, for this letter to be written, hoping to deter some of the unfair, one-sided finger-pointing of corruption and malpractice being directed at me only by those in the, quote, justice, quote, system, who are trying to deflect the shame and shock from me fearlessly challenging the status quo. And it must be so, because it's in my face, on the computer at the same time, on my boob tube television, brainwashed, ignorant, followed of disbelief, conformity, and greed, trying unsuccessfully to make my life, by character assassination, seem worse than theirs. No, 2. When anyone points their finger, 1. It's impolite, and 2. 3 point back at you. How many tried to see? Put the stone down, as there will be no casting of anything together, except for maybe for the role of my part of the all pre-conclusioned, quote, documentaries, and crystal ball, real-life stories of, quote, true crime, incorrectly formulated from everyone supposedly knowing me and judging who they think I am, what really happened and is going to futuristically. Remember, 3 more point back. Soothsaying is not a real job. Alright, so pausing again, but throughout most of her letters, Sarah does a decent job sticking to a couple of ideas. Sure, what she is saying is mostly nonsense and her trying to validate murder, but she stays on topic for the most part. But here, she really loses the plot. I might be daft, but I've yet to see anyone who claims to be a sidekick talk about this case with any sort of authority. The only thing I've seen is channels like mine state they believe Sarah is either going to represent herself at trial or be held in contempt for her behavior. And each time they make it clear that these are just assumptions based on what she has already done. She continues on. To sum it up in the words of my attorney, after I told her to Google me, she stated, "There's a lot." To sum it up in the words of myself, the defendant stated to my attorney after she stated that to me, "When can I see? How much longer do I have to wait? Or how many attorneys must be withdrawn for me to be included in my case?" And be included more than the world presently is. Pausing once more, after reviewing Sarah's letters, it's clear that she feels blameless in all areas of her life. Jorge dying, not her fault. Her lawyers withdrawing, not her fault. Her ex-husband not wanting to be around their child, not her fault. These are all random things being done to her. She has done nothing to earn. But that's not really how life works. If you had 8 competent lawyers working for you and they all separately withdrew, citing ethical considerations and your bad behavior, you would think that that would be cause for introspection, that you would take a moment to realize the way you've been handling yourself might be a bit abrasive, or that you had made multiple social faux pas. There'd be a bit of self-doubt, and you would be forced to examine if you are the problem in these situations, since you are the only common thread. But not Sarah. She does not live in a world where she can be wrong, or she could have caused any of this chaos. Sarah continues, "This is my case in every aspect. See all of my aforementioned ongoing 5-year questions I am still waiting on for answers. Also, I want to make it known, I walked out on my attorney in our last meeting due to her unwarranted, uninformative, unprofessional, snotty attitude and her untruthful answers to my questions and beyond. The quote, retarded vicious cycle we enter every time we meet is a waste of time. And I'm that being in jail with supposed endless amounts of. How she treats me is extremely prejudiced, hostile, and unconcerned. She is very frustrating. Number 1, to balk in defeat in an endeavor. Number 2, to induce feelings of insecurity, discouragement, or dissatisfaction in. Number 3, to bring to nothing. Alright, so pausing once more. As previously mentioned, whatever is said in this letter is so bad that her lawyer immediately filed a motion to withdraw from the case. But something that should also be noted is the fact that Sarah has talked this poorly about every single one of her attorneys, but never fired them herself. She will emphasize that much in this very letter, drawing attention to the fact that it's always the lawyers quitting on her, not the other way around, which poses the question, why does Sarah want to work with people who she doesn't have faith in? If you've ever been around an individual who acts in a similar way as Sarah, then you would know that they are prone to throw any and all accusations at the wall when they are upset with you. In my personal experience, it doesn't matter how small the perceived slight is. They will throw everything they can at you in anger. You could have implied they made a small mistake, and they respond by exploiting a sensitivity you told them about in confidence, only to downplay what they said and did afterwards. This is truly a linguistic ability that some consider to be unnatural, as Sarah doesn't actually believe her lawyers are bad. She doesn't think they are incompetent and unable to provide her with a good legal defense. She just doesn't like the fact that she isn't the one in charge. Every time they tell her no or rebuff one of her suggestions, she takes it as a personal slight, then feels justified in telling the whole wide world that they are bad at their jobs and should be disbarred. Does she actually want them to be disbarred? Does she actually want them to quit? Probably not. She just wants to hurt them for hurting her ego. Keep that in mind as we continue on, because despite everything she states, she doesn't actually want her lawyers to quit. Continuing on. So much I presented my solution in order to coexist with and work together in a hopeful, progressive, positive, appropriate manner. I added, quote, pretend judge to our interactions so she could calm down and ease up on her condescension, offensive demeanor, and obvious prejudgment. She seems, like everyone else, to not remember I am innocent until adjudged otherwise. She treats me as if I'm not. After my introduction and explanation with, quote, pretend judge, in the room or on the phone, I am trying to help her understand how she is making herself extremely unwelcoming when in front of a real judge, and in the courtroom is how she treats me, her client, at all times. I should not have to invent, quote, pretend judge, in order to be, and not at all wrong for wanting to be, respected, no matter the outcome. I am innocent until adjudged otherwise. My attorney, everyone's, should be fair, unbiased, trustworthy, honest, supportive, informative, protective, automatically and effortlessly. These lawyers should be automatic, they should be systematic, and hydromatic. Okay, but really, I should feel secure, highly confident, proud in her, quote, representing my life. I do not, and have said to her many times regarding her monumental disbelief in me and my case, which I believe contributes greatly to her inimical attitude towards me. I am hoping by this letter she will pick up the sword of injustice and fight alongside, not against me, as so many unmotivated, overwhelmed, weak attorney prior who have bowed out ungracefully and crept away from the battlefield unsuccessful. What I also appreciate is that Sarah just put it all out there. She wants her lawyer to be subservient to her, to provide her with everything she asks for regarding the case, and to treat her as if she has done nothing wrong. But she has done a lot wrong. She murdered someone, she's in jail for murder, she has harassed 8 lawyers to the point where they quit her case, and she sees nothing wrong with it. The only way Sarah would be happy with a lawyer would be if they told her that they believe she is innocent, only responded positively to the stupid things Sarah is constantly saying, and never provided her with any sort of legal counsel. But she continues on. My case equals bizarre, equals unknown, equals different, equals ignorance, equals misunderstood, equals unfair. This does not mean my case can't equal success in more than one way. While everyone else continues to ring their, quote, bells of malevolence, I am ringing mine of hope, honor, plausibility, boldness. Listen, I am not a murderer. The justice system should equal fair, faith, trust, respectful, innocent until and if adjudged otherwise. 3-point back, Sarah Boone. Heart confused cat meme? Yes, thank you. So that is the end of the first portion of the letter. But it's far from over. I was originally going to read the entire thing, but as some portions are just legal definitions copied down, I will skip those portions for the sake of brevity. I will be leaving a link to the county clerk's website, should you want to look up the whole letter for yourself. The letter continues. June 4th, 2024. Video visit 12 minutes. In addition to my previous letter intended for hand delivery on 6/7/2024 at my, quote, status hearing, today my attorney made a video call to go over everything I've been asking her for, and I've also sent to her personally in 2 letters, 5/20/525, all in the public video visitation box, where on both sides of me, other inmates were having their visits also. I have explained to my attorney numerous times previously in writing and verbally that despite the noise level, I do not in any way feel comfortable having an in-depth, private meeting regarding my entire criminal case on the visitation box where there is no privacy whatsoever, and hold in an open bay dorm with more than 62 other interested, all-ears inmates. I cannot fully participate, if at all, from the entire dorm, officer included, trying to participate also in my case. As always, my attorney did not listen or care after I repeatedly tried reminding her of my insecure environment, barking at me that I can listen or not, still going, over-speaking, and not at all allowing me to respond. Pausing again, in every other letter that we've gone over of Sarah's, she states that her lawyers refuse to speak with her at all. She talks about how she writes them letters. She has her friends and family call them at all times of day, but they refuse to correspond with her. But now we are getting a more detailed picture. She probably won't shut the fuck up. Sarah only wants to be communicated with on her terms. She wants her lawyers to come to the prison to reserve a private room and speak to her as if she is on a legal team with them. She wants to be talked to not as a client but as a peer, and the fact that they are not doing this is upsetting to her. The fact that her lawyer had the audacity to schedule a video visit instead of an in-person visit is too much for her to take. While it's not ideal to conduct a legal meeting via the visitation box, it's also not ideal to be in a prison awaiting trial for murder. Sarah doesn't have a lot of options, and the fact that her lawyer is willing to sit down with her once more to try and answer her questions is a good thing, but all she can do is disrespect. She continues, after repeating to her over and over and over while she's beginning to speak louder and over me, still to please schedule an in-person meeting where all can be discussed further, privately with no success of being heard. I disconnected the visit telephonically, she uncooperatively. She is impossible. See my previous letter or ask her for a copy of the two I sent to her. I was trying to remedy or lessen before sending this to you, Your Honor, and not having to include. Now it's a race to the pulpit. My next question, please. Who acts like that and is still able to call themselves, quote, professional? Pausing again, there is something incredibly ironic about accusing someone of being unprofessional for trying to work with you after stating that you hung up on them. She continues, the visitation box is primarily for family and friends to connect, and, if a must, from an attorney. Reminder, notices, quick questions, not high-level confidential case information. She, like other former attorneys who always blame their dysfunctions on me, said, I'm trying to do this without yelling, you don't like the answers I give you. What answers? See pages 1, 2, and 3. I am not the problem, except that I want to and should be treated fairly with respect, acting more professional than the paid. I've been doing this for 40 years, professional. After so long, and in all the experience, common courtesy, customer service, and listening skills should have been acquired. Okay, so pausing again, but needless to say, Sarah kind of illustrates how she is the problem when she says all the things like this. But because she cannot see herself as anything less than amazing, she has to invent conspiracies as to why things aren't working out for her. It's not her fault. It's the 8 lawyers, and Judge Wooten, and Law and Crime, and Court TV, and so on. She is just a hapless person it's all happening to, and she is just at the center of it for some unknown reason. Having one lawyer who couldn't handle their caseload and wasn't equipped to take on her case is normal, but she's gone through 8, and they have all had the same experience with her, so she might be the problem. Sarah continues, all attorneys. Do you even remember why you even wanted to be one? Remind yourself, no one listens, and it works in everyone's favor but mine. That I'm a murderer stuck in ale so they can pin on me. They're uninterested, unmotivated, hopeless. They're going to believe me over her haughty attitude. I am not wrong for not thinking less of myself because everyone else has and does. This present attorney foremost. The, quote, justice system expects me and other inmates, aka, quote, clients, to accept its subpar, nonchalant, hypocritical, quote, next on the list, attorneys they keep aimlessly throwing darts for, and malappointing, praying they don't withdraw. I have not fired any attorneys appointed in my case. From me expecting the highest, equal, standards possible for watching the absolute best outcome in my preposterous, mismanaged case. Alright, so pausing again, Sarah has lambasted each and every one of her attorneys, and just attorneys in general. She has said that they are lazy, they don't know what they're doing, they should be disbarred, they should undergo ethics investigations, and she said every lawyer's specific insult you can think of, and yet, she also contends that she would be okay with each and every one of them representing her. It's kind of nice. Put yourself in Sarah's shoes. You're on trial for murder, and you believe your lawyer isn't a lawyer at all. They're a sack. Maybe if you were incredibly depressed and thought there was no hope, you would let a lawyer who you felt was terrible at their job represent you. But if you believed you were some freedom fighter who was exposing a corrupt system through their case, you'd want to work with someone who you thought could actually help you. But not Sarah. She continues, and, quote, representing myself is not an option, as both judges have now threatened me with from being outspoken and intelligent in all my observations of the ongoing abuse I am and have experienced. I have no new experiences from it, always being the same, blame Boone. I refused to be moved in wanting respect, no matter who everyone thinks I am. Clarity, inclusion, honesty, and professionalism. And another great reason not to have my case meeting on the public visitation box is my personal, confidential inmate information, such as my visitation lists with names, my interactions with other inmates and officers, when I eat/when, and my personal jail calls also being thrown online. For what? To hate me more, or to try and get others to, because I don't eat breakfast, or because I know some Latin, I have short hair, my penmanship is nice, or because I'm not getting fat and sleeping all day, but rather fully applying myself, fighting still, making everyone upset from not having to fabricate, mutate, splice, edit. The world apparently knows all. What's next? How many times I go to the bathroom and what function I perform? No one knows anything, nor seems to want to, from being comfortable in their corruption and striving to be, quote, on top with rating, web hits, and money. My case details, if anyone forgot, and if you think about it, all that keeps getting plasters and plagiarized, okay? Posted and poked fun at about me. It's all in my favor, proving myself right about all the mindless lemmings, shut-ins, the, quote, justice, quote, system, advantageously abusing and profiting from everything in my case/cases before my trial and before I've seen. Please be sure to read my attachment for FRCP Rule 3.220, parentheses E, restricting disclosure. Am I the only one who thinks of these things? When can I win? In anything. It's coming. I am not the problem. And if anywhere were to slip on my slides and had to experience, tolerate, deal with any of what I have and am, would bravely be doing the same. Don't know till you try it. 3-point back. Race to the pulpit. Again, always. Sarah Boone. Alright, so skipping forward over some pages of her defining words like attorney misconduct and zealous advocacy, she then writes, the number grows daily. Most all letters and messages are available for review and understanding of the impact my case details being made readily available on the global internet, creating wrongful ignorance, hate, and massive prejudgment before my trial. I, the defendant in my case, have not yet, ongoing 5 years, fully reviewed or even seen all of my case details. Everyone in the world has already had the opportunity to do so themselves. The continuation of the obvious exploitation allows the world to keep pressing their incorrect, presumed unfair theories, ideas, accusations, forcibly insinuating I committed, quote, criminal acts. My present attorney said it's, quote, not necessary to receive a court order that I've been trying to obtain to download my case information to apply from the OCCD tablets. My former attorneys are withholding some of my case contents I have supplied to them, and which have been deemed lost. Many other items have been returned, but not to myself, but to the, quote, next attorney, and which have been unable to be located to date. I am missing innumerable case items, which I continuously request to be returned or obtained without success. Pausing again, she then goes back into defining legal terms that the judge and all the lawyers in her case would already know, before writing what she thought would be the most damning note of them all. This is her big closer. For some fucking reason, she needs a big closer right now. She continues, publicity, exploitation, and saturation. My personal, individual, quote, criminal case is being advantageously exploited and abused from all my significant, life-saving, suppressible case details, evidence, proof being illegally obtained by coercion, trickery, duress, confusion, and without my permission, in any form, written or verbal, to anyone, then broadcasted, distributed, hand-delivered to the entire planet, states, countries, continent, things that are on a planet, containing all my potential jurors, causing irreparable, erroneous, falseness, tainting my jury pool altogether by forcibly attributing heavily influenced, incorrect, inappropriate motives, theories, and ideas. This obvious exploitation and invasion of my privacy is creating unnecessary, unlawful oppression, depleting all of my entitled opportunities to be given a fair, proper, successful conclusion to my case. A misprejudgment has already been made unfairly against me from the undeniably violations of my constitutional rights and due process of law as a result of my entire case and personal life being publicized globally before my rightful trial, which lawfully ethically should be without disadvantage and free from all partially deceitful and dishonesty made from said evident exploitation. Okay, so there you have it. Sarah Boone is still in prison, she is still harassing her lawyers, and she believes that everyone who has followed this case online is a part of a grand conspiracy to keep her in prison. This cause came before the court on June 28, 2024, on defense counsel Patricia A. Cashman's Esquire motion to withdraw as counsel filed June 11, 2024. The court, having reviewed the motion, having reviewed the court file, having reviewed the audio transcripts from various hearings, having considered the positions offered by counsel Patricia A. Cashman Esquire, having considered the testimony offered by defendant Sarah Boone, and having considered the positions offered by counsel for state, hereby finds: A. On March 23, 2020, by way of information, the defendant was charged with second-degree murder. B. On February 26, 2020, the Office of the Public Defender, 9th Judicial Circuit, in and for Orange County, Florida, was appointed to represent defendant. C. On March 9, 2020, the public defender moved to withdraw due to the defendant retaining private counsel, to wit Mauricio Padilla Esquire and the Padilla Law Group. D. On March 11, 2020, that certain order allowing withdrawal was entered which withdrew the public defender from further representation of the defendant. E. On April 18, 2022, Padilla moved to withdraw due to irreconcilable differences between undersigned and the defendant that may have made it possible for undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the client. This motion was served upon the defendant and defendant confirmed receipt. See letter dated April 20th, 2022 and filed on April 26th, 2022. F. On April 29th, 2022, a hearing was held on Padilla's motion to withdraw. At the time of this hearing, Padilla had been representing defendant for 2 years. Defendant was present for the hearing and was sworn. The court advised Padilla that the court had received a letter from defendant, a letter dated April 20th, 2022 and filed on April 26th, 2022, which seemingly objected to Padilla's withdrawal. The court advised Padilla that the options were not to proceed on Padilla's motions to withdraw and provide the court more about the irreconcilable differences. Padilla requested an opportunity to amend the motion to address the irreconcilable differences. The court reserved ruling on Padilla's motion to withdraw, gave Padilla until May 3, 2022 to prepare and file an amended motion with a hearing to be heard on the week of May 9, 2022. The state advised of Padilla's diligence in preparation, and the court commended Padilla's work. Defendant testified to a, quote, lack of trust between herself and Padilla. G. On May 4, 2022, Padilla filed an amended motion to withdraw, which supplemented the original grounds. Number 1. Undersigned's relationship with defendant has become adversarial. The aforementioned adversarial relationship has interfered with undersigned counsel's ability to effectively represent his client, especially preparing for trial. Number 2. Undersigned appreciates the court providing him the opportunity to amend his previously filed motion to withdraw. However, after further researching the issue, undersigned is still under the belief that the specifics of the adversarial relationship may disclose information that may prejudice his client and as such will stand mute on the specifics. H. On May 6, 2022, Padilla filed a second amended motion to withdraw, which further supplemented the original grounds. 1. Undersigned relationship with the defendant has deteriorated to the point where undersigned counsel can no longer give effective aid in the fair representation of Miss Boone's defense. I. On May 10, 2022, a hearing was held on Padilla's second amended motion to withdraw. defendant was present for the hearing and was sworn. Padilla advised the court that he had no other choice to file the motion due to ethical concerns. Defendant confirmed that she wanted to terminate Padilla as her attorney. The state expressed concern of a strategy to allow defense attorney after attorney to represent defendant. The court advised defendant of the state's concern regarding a strategy of defendant being unhappy with every attorney and advised defendant about the dangers of self-representation. The court appointed the public defender, attorney number 3. J. On June 6, 2022, the public defender moved to withdraw due to a conflict. K. On June 7, 2022, that certain order allowing public defender withdraw was entered, which withdrew the public defender from further representation of the defendant and appointed the office of Criminal Conflict and Civil Regional Counsel. L. On June 10, 2022, RCC moved to withdraw due to a conflict. M. On June 22, 2022, that certain order allowing the Office of Criminal Conflict and Civil Regional Counsel withdraw was entered, which withdrew RCC from further representation of the defendant and appointed Mark Consolo. N. On July 8, 2022, the Consolo moved to withdraw due to a conflict. O. On July 11, 2022, that certain withdrawal order was entered, which withdrew Consolo from further representation of the defendant and appointed Frank J. Bankowitz. P. On July 12, 2022, Bankowitz, in open court, requested a continuance due to his recent appointment, and the same was granted. Thereafter, the court set a pre-trial conference for October 25, 2022 at 9 a.m., and trial during the trial period began November 7, 2022. Q. On October 25, 2022, the court held the pretrial conference and addressed the court's understanding that a continuance was being sought and the court's judicial assistant was to reach out to the parties to confirm if a continuance was being sought. R. On October 27, 2022, Bankowitz filed defendant's motion to continue. S. On October 28, 2022, the court entered that certain amended order on defendant's stipulated motion to continue, which set a pretrial conference for January 17, 2022 at 9 a.m. and trial during the trial period beginning January 30, 2023. T. On November 22, 2022, the court set a status hearing on Tuesday, December 20, 2022 at 10:45 a.m. U. On December 19, 2022, Bankowitz moved to withdraw due to the irreconcilable differences which have arisen between the undersigned, his client, and his family. The undersigned will be unable to effectively and properly continue representing the defendant herein. V. On December 20, 2022, the status hearing was held. Bankowitz did not appear due to a car accident, and the court reset the status hearing for December 22, 2022 at 11 a.m. W. On December 22, 2022, the reset status hearing was held. Bankowitz appeared virtually, and due to technological issues, Bankowitz was unable to hear the court. The court reset the status hearing for December 27, 2022. X. On December 27, 2022, a hearing was held on Bankowitz's motion to withdraw. Defendant was present for the hearing and was sworn. The court advised defendant that the court had received letters from defendant. The court conducted a Nelson hearing, and defendant was not seeking to remove Bankowitz. Bankowitz advised the court of the thousands of pages in discovery that he had reviewed and organized, and his contact and potential use of and collaboration with expert witnesses, including experts that Padilla utilized. Bankowitz advised the court of defendant's attempts to call Bankowitz at a rate of 5 to 10 times a day. Oh, how does she have access to a phone that often when she's already in the jail? Bankowitz further advised of his efforts to balance the demands of other clients with the defendant's expectations for communications. In response, defendant reposted that Bankowitz's representations were untruths, raised Bankowitz's prior public reprimands for lack of communication, alleged Bankowitz's action in this case rose to a similar level, and then sought to remove Bankowitz. The court pointed out defendant's inconsistent statements within minutes of them being made and addressed concerns over defendant's motivations, especially when there is something defendant disagreed with. The court specifically advised defendant that she is, quote, not entitled to an endless line of court-appointed lawyers until you find the one that you personally prefer. The court also explained the circumstances where the defendant could represent herself. Ultimately, defendant did not request to remove Bankowitz. The court denied Bankowitz's motion to withdraw and directed Bankowitz to have a conference with defendant prior to the pretrial conference previously set for January 17, 2023. Why? The case was continued several times due to Bankowitz's attempts to retain an expert through JAC and JAC's response to the same. Z. During this time period, the court had received several letters from defendant. On August 22, 2023, Bankowitz again moved to withdraw due to 1. Irreconcilable differences between undersigned and the defendant that have made it impossible for undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the client. 2. The defendant will not be satisfied with any attorney unless the attorney does not have a caseload and can delegate his or her time solely to Miss Boone's case. Number 3. The best possible avenue is to have the defendant represent herself as no attorney can satisfy her. BB. On September 8, 2023, a hearing was held on Bankowitz's motion to withdraw. Defendant was present for the hearing and was sworn. Bankowitz addressed defendant's derogatory statements, i.e., dud, buffoon, and berating behavior. The court advised defendant that the court had received letters from defendant. After the court's colloquy of defendant and her acquiescence to Bankowitz's withdrawal, the court granted Bankowitz's motion to withdraw and appointed Winston Hobson. Thereafter, the court set a status conference for October 30th, 2023 at 10 a.m. and set a pretrial conference for November 28th, 2023 at 9 a.m. After setting these dates, the court pointed out the deterioration of the working relationship between defendant and Bankowitz. The court further cautioned that, quote, if this becomes a problem on another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. The court further advised that there are certain decisions the attorney gets to make and certain decisions a defendant gets to make, i.e., go to trial and/or testify. The court cautioned as to defendant's unrealistic expectations regarding court-appointed counsel and reminded defendant of her right to retain private counsel, CC. On October 30th, 2023, the status conference was held. Hobson advised to his conversations with defendant and setting a status in January 2024. Thereafter, the court set a pretrial conference/status as to readiness for trial for January 16th, 2024 at 9 a.m. and trial during the trial period beginning January 29th, 2024. DD. On January 12th, 2024, Hobson filed that certain motion to continue, waiver of presence, and requested a 3-docket continuance. EE. On January 16, 2024, the court addressed Hobson's motion to continue, granted same, set a pretrial conference for May 3, 2024 at 9 a.m., and trial during the trial period beginning May 13, 2024, FF. On February 1, 2024, Hobson moved to withdraw due to irreconcilable differences, including but not limited to ethical considerations, GG. On February 9, 2024, a hearing was held on Hobson's motion to withdraw. Hobson addressed a number of issues as for the basis for withdrawing, including disagreements on legal strategy, on what can and cannot be done, a lack of resources, and defendant's demands make her difficult to work with, including defendant taking non-viable legal positions and being unreasonable. As to a key substantive defense, Hobson advised that the retained and undisclosed expert is not keeping with what defendant has in mind. The court advised defendant that the court had received a letter from the defendant. The court outlined the overriding claims for withdrawal by Padilla, Bankowitz, and Hobson, as well as adversarial relationships, lack of satisfaction, and inability to meet defendant's desires. The court found that all of the defendant's relationships with all of the court-appointed counsel have deteriorated such that defendant and the court-appointed counsel cannot work together. The court advised defendant that although defendant has the right to court-appointed counsel, that right is not unlimited. The court twice advised defendant that defendant may not be provided another court-appointed attorney and that defendant would have to represent herself if the circumstances similar to Hobson's motion to withdraw occur. The court further advised defendant about the dangers of self-representation due to defendant's lack of legal training and knowledge. Defendant never stated that she did not understand that she may not be provided another court-appointed attorney. The court granted Hobson's motion to withdraw and appointed Patricia A. Cashman. The court is aware of Cashman's extensive experience representing criminal defendants as both an assistant public defender and in private practice, including representing defendants accused of murder, and is widely known to be able and willing to deal with and manage difficult clients. The court set a status hearing for April 12, 2024. HH. On April 12, 2024, the status hearing was held. Cashman advised as to the depositions that had been set. the hiring of an expert, and a request for a future status date to address a trial date. The court set a status hearing for June 7, 2024. 2. On June 7, 2024, the status hearing was held. Cashman addressed her dates of availability for trial. Defendant was present for the hearing and was sworn. Thereafter, defendant advised the court to walking out of multiple meetings with Cashman, which was confirmed Cashman utilizing a pretend judge to oversee defendant and Cashman, launching multiple attacks on Cashman's professionalism. Cashman advised to her efforts and time spent on the case so far, 20 hours. Cashman addressed disagreements on legal strategy, including defendant attaching importance to issues that may not legally be important. In her post, defendant accused Cashman of lies and half-truths. JJ. On June 11, 2024, Cashman moved to withdraw, citing irreconcilable differences, including but not limited to ethical considerations that have arisen such that counsel can no longer provide representation. KK. On June 28, 2024, a hearing was held on Cashman's motion to withdraw. LL. At no time has defendant refused to accept the services of any of her 7 appointed attorneys. OO. A defendant in a criminal case can forfeit the right to a court-appointed counsel. QQ. As set forth above, defendants' recalcitrance to the attorneys who were not conflicted out, Padilla, Bankowitz, Hobson, and Cashman, antagonism, hostility, and attacks on professionalism of Padilla, notably, over a year after the fact, see footnote 9 above, of Bankowitz and of Cashman, and personal attacks on Padilla, Bankowitz, and Cashman. Each of these attorneys were required to withdraw. RR. It has become apparent to the court that defendant will not permit herself to be represented by anyone. SS. Additionally, the withdrawal of 8 different attorneys, 7 of which were court-appointed, leads to a determination that defendant had forfeited his right to counsel. UU. As the court finds defendant has forfeited the right to court-appointed counsel, under Florida law there is no obligation to conduct a Feretta hearing, or to otherwise warn a defendant of the dangers of proceeding. VV. The court can find a waiver by conduct to right of counsel. A waiver by conduct requires that a defendant be warned about the consequences of his conduct, including the risks of proceeding. WW. On February 9, 2024, defendant was twice advised that another court-appointed attorney may not be provided. XX. On May 10, 2022, defendant was advised about the dangers of self-representation. YY. On February 9, 2024, defendant was advised about the dangers of self-representation. ZZ. As of February 9, 2024, the instant case has been continued 16 times. AAA. As of June 26, 2024, this case has been pending 4 years, 3 months, 5 days, from the date of the filing of the information on March 23, 2020. BBB. Actions speak louder than words. Although defendant's words seemingly reveal a desire to go to trial, however, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over. Allowing defendant her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further and encourage defendant to persist in efforts to prevent the resolution of the case on its merits, the concept of which was first brought defendant's attention on May 10, 2022. Defendant complains that Bankowitz and Hobson, 2 court-appointed attorneys, failed to meet and communicate, and when defendant is provided court-appointed counsel who will meet and communicate, Cashman, the ways and means of meeting and communicating are unacceptable to defendant. Number 1. Cashman's motion to withdraw as counsel filed June 11, 2024 is granted. Number 2. As a condition of Cashman's withdrawal, Cashman shall provide the court an order for costs to obtain transcripts of depositions for the 2 witnesses Cashman deposed. Upon completion of the transcription of the depositions transcripts shall be sent directly to defendant, Sarah Boone, by Cashman at the Orange County Jail. Thereafter, Cashman shall file a notice with the court reflecting that the depositions transcripts were provided to defendant Sarah Boone, and such notice shall include the date sent and the address of defendant Sarah Boone. Number 3. Defendant Sarah Boone has forfeited her right to court-appointed counsel. Number 4. Alternatively, defendant Sarah Boone has through waived by her conduct her right to court-appointed counsel. Number 5. The trial management conference shall remain specially set for Tuesday, September 24, 2024 at 1:30 p.m. Number 6. This case shall remain specially set for trial for the 2-week trial period beginning Monday, October 7, 2024, and will not be continued for any reason except by extraordinarily good cause, or such extraordinarily good cause shall not include retention of counsel by the defendant. Number 7. Any and all pretrial motions in this case must be filed no later than the close of business on Monday, July 22, 2024, done and ordered in chambers at Orlando, Orange County, Florida, this 28th day of June 2024. When we initially covered the case, I did not expect to be talking about it nearly years out, but here we are. Let me know your predictions about this case in the comments down below. With all of that said, thank you so much for watching, and if there's any content you would like to see on this channel or a video you want to see made, email me at dreading.official@gmail.com. With all of that said, have a great day and remember to stay safe.